One of the questions a lot of our clients will ask is, well, what happens in jury selection? It's a common question when we get to that part, because it's often overlooked. It's not the piece that you see on television at all. You see what's happening at trial, the drama at trial. But my honest opinion and feeling about this, and I think a lot of attorneys feel the same way, is that jury selection is actually a lot of fun. It's where a lot of the drama actually lies, because you get to interact with the jury. It's the one piece of the trial where you get to stand up in front and ask them questions and have a conversation. And the point of jury selection is really to eliminate jurors. We often refer to it as jury deselection. What the goal is to eliminate jurors that have potential biases. What we're aiming for, both sides together, the court and the plaintiffs and the defendant, is to get a unbiased, neutral jury who is capable of judging a fair trial. So the plaintiffs get an opportunity to talk to the jurors and eliminate folks that they think are unfavorable towards the plaintiffs, and the defendants, they get the opportunity to do the same thing. The challenge about jury selection is that you have a very limited amount of time to try to figure this out. You've got a large panel of 40, 50, maybe more jurors that are brought into the courtroom, and you're trying to, in a district court case, limit that to 12 people. So many times you'll be offered, depending on the length of the case, longer or shorter periods of time which each party gets to speak to the jurors. But very often it's, a half hour, maybe 45 minutes. If you're lucky, you can go an hour, 2 hours on a longer case, a larger case, more complex issues. But you get to talk to these folks and find out who they are, and they get to learn a little bit about you. That doesn't happen any other time during the trial. It's a good time to make a connection with the jury, let them know that you're a real person. You're not just a mechanical robot attorney standing up just trying to iterate the facts of a case. You're really trying to build that connection. Like I said, what the goal is to eliminate biases. And I'm not talking about biases that are necessarily racial or gender-based or age-based or something like that, religious-based. Obviously, those are important issues to draw out. But we're talking about issues like, can you award non-economic damages? Or are there any folks in this room here who in this room here just cannot award damages for pain and suffering? Now, the legal system allows for that. That's part of the types of damages that you can claim in a personal injury case. But there are jurors out there who that's a bias that they hold. I just cannot award damages for pain and suffering. I don't think it's something that people should be entitled to. Now, if the juror is unable to follow the law because they have that particular bias, then it would be appropriate to dismiss them from the case. Now, oftentimes jurors are dismissed from cases and they'd be perfectly appropriate for another case down the hall, but just not for this particular case. And that might be for a reason such as they have a bias against plaintiffs' attorneys. That's a bias that comes out, fairly frequently. Folks have, judgments and biases towards plaintiffs' attorneys, maybe towards defense attorneys, or maybe towards attorneys in general. Maybe they had a past life experience that caused them to develop this bias, and they think, I had a bad experience with a personal injury case of mine or with a family member, and there's just absolutely no way that I could ever trust this person in front of me speaking. And we need to know about those things, because the point is to have a fair trial. That's the bedrock of the system that we have. So jury selection is a great opportunity to learn about the jurors, learn about what they understand about the law, what they understand about legal standards, and try to instruct them about important issues in the case. When I talk about legal standards, we need the jury to understand that in a civil trial, we're dealing with a legal standard of a preponderance of the evidence, not a standard of beyond a reasonable doubt. That's appropriate for a criminal trial. So we're trying to prove our case. The burden is on the plaintiffs to prove their case by a preponderance of the evidence. And jurors don't know what that means. Most folks don't know what that means. Even law students and lawyers don't always know how to explain what that means. But what it is essentially you're trying to show that the greater weight of the credible evidence, which essentially balances the scales just beyond 50%. If you can show that it is more likely than not that this fact is true, then that's a basis by which the civil trial is run. We don't have to prove our case the same standard as a criminal case, where the jurors have to feel that in order to find for the plaintiff, they need to be absolutely certain or beyond a reasonable doubt of certainty. We just have to show it's more likely than not that these facts are true. Jurors might not be comfortable with that. And we need to instruct them on these issues, and we need to determine whether they're comfortable judging the case at that level. Some jurors are not. They might say, I cannot find for a plaintiff unless I am certain. And certain means beyond a reasonable doubt. Well, they wouldn't be appropriate for a civil trial juror. So those are the issues that we're trying to tease out in jury selection. And again, it's very challenging to work through all those issues in a short period of time. But that's part of what makes it a lot of fun. The opportunity to talk to jurors, to connect with them, and to try to tease out these issues strategically and as quickly as you can in order to get a fair jury that can judge your case and is capable of working out what would be a just outcome in this case.